Who's a judge to say that like they're not a member of your family when like 90% of Americans would say that they're part of your family?
Welcome to the Animal Law Podcast, which is, of course, as you probably know, part of the Our Hen House channel of podcasts. And please remember to subscribe and hit like. And today it's my pleasure to welcome back Christopher Berry, who is now, he wasn't before, but he is now the executive director for the Non-Human Rights Project, where he is responsible for overseeing action to secure legal rights for animals through litigation, legislation, education, and other efforts. And I'm sure you've all heard of the Non-Human Rights Project, and it's just very exciting to have Christopher here in this new job. Prior to working at NHRP, he helped manage litigation at the Animal Legal Defense Fund, where he specialized in private civil enforcement of animal protection laws and related issues such as standing, justiciability, and procedure. And I'm so excited to have you here. Welcome, Christopher.
Thanks for having me. Also excited to be here. And thanks for the lovely introduction.
One of the reasons I'm excited to have you here is that, I feel like we've been talking about like big environmental issues and talked about alligator Alcatraz last week. And this week we're going to be talking about an issue that is far more personal and yet I think I'm sure you'll be able to do this, put in context is so important. And one of the reasons I feel that way is because when I've taught animal law, I almost always, I mean, my first class is introductory, but my second class will always be on the relationship between tort law and animals and companion animals. And everybody in the class, and whether it's the student who knows absolutely nothing about animal law or the one who's really, that's why they came to law school, they're all shocked. I mean, I think it is the issue that really brings home to people more than anything how crazy the law is when it comes to animals. So before we get to the specific legal issues here, which involve a case, an ongoing case in Brooklyn, which people may have heard a bit about, can you just give us the background overview on the bizarre status of tort liability for harm to a companion animal in the U.S.?
I think the best way to understand how messed up it is this, I think it was a 2013 Texas Supreme Court decision, Medlin v. Strickland. This was a case where a companion animal, a dog, went to the shelter. Family was told to come back on the weekend after the holding period to pick the dog up. The dog had been euthanized in the interim, so there was a action against the city shelter for negligence for killing the dog. And the question was under Texas law whether you could get sentimental damages. So normally with property, you're limited to the market value. If someone totals your car, you don't spend $1 million to uncrinkle the car. You just get money to go buy a new one. But for certain forms of property, even that doesn't quite work. Like family heirlooms are an example of that. So Texas recognized sentimental damages, and the issue was whether the death of a companion animal was limited to market value or whether you could get sentimental damages as you could in Texas for like a family heirloom. And the Texas Supreme Court said no, for an animal you're limited to the market value, and there was some like 1800s case involving I think like a guard dog on a farm or something like that they said we're just going to stick with that really old precedent. And what was remarkable and why this is the example that I want to lead with is that there was this hypothetical like, well, what if the family had a family heirloom that was a taxidermied dog and that was destroyed? And the Texas Supreme Court, like to their credit, acknowledged that hypothetical, and they kind of just shrugged and they're like, yeah, like you could get sentimental damages for a taxidermied family heirloom dog that was destroyed, but not for a living one. And so to me, like that perfectly captures the absurdity of the current status of companion animal valuation under tort law.
Yeah, it really does. It's a great example. And I also just want to share that it's not just Texas. I think every single time this issue has reached the lower courts have gone different ways and tried different things, but every time it's reached the top court in any state, they've said no. They're they're not worth anything pretty much because market value. Let's face it, your old dog ain't gonna bring a lot on the market.
No, in fact, I've haven't done this analysis, but I've wondered if even someone would someone who intentionally killed like a geriatric dog that was costing a lot of money with healthcare, whether they might actually have a restitution claim. They might be able to sue the owner for restitution. Like, I just saved you $10,000 on radiation therapy for your dog, so give me
Yeah.
10,000, So it is absurd, and yeah, and you're exactly right. This is the Texas example is really representative of the the nation at large, all the 50 states. There are some, but there is like some a little bit of like turbulence there too. Is it, decisions where they'll say, well, you can at least recover the if you have to go to the veterinarian to save their life, you could at least get the vet costs.
Even if they're more than the market value of the dog.
Yeah, exactly. Even if it's more than the market value.
Whereas with other kinds of property, you can't get repair costs if it exceeds the market value. But so that truly is really a variation, a little exception.
Yeah, and also receiving emotional distress damages for intentional infliction, right? And it's you're sort of likening it to like punitive damages or sort of a punitive aspect there. But then there's still that recognition that like you can be emotionally distressed when your member of your family perishes.
And also, there's just a few cases, like there's that New Jersey case, I think, like they tried to up the value of the dog by saying the dog could do tricks, as if that's what we value about our dogs. But they try to bump it up a little bit in a fake way.
Yeah, and so I think this like absurdity, right? That they're the tricks and the like your market value, but we'll still let you recover for veterinary costs to keep them alive. The taxidermied dog being able to have sentimental damages for destruction, but not the living family dog. Like the I think this is actually evidence of like incredible tension that's like brimming
Yeah,
underneath. Like we have this
yeah.
general rule that you're limited to the market value because companion animals are property. Like that's sort of the general textbook, the most simple kind of way of explaining it. But when you really look into the details and really dig in, there is incredible tension, and I think that's what you indicated when you bring this up in your classes that there's that sort of disbelief at the current state as well.
Yeah, which I think that shows what an important issue this really is in our relationship with animals. It's where the rubber really it hits the road, but people are pretty unsatisfied with where it's hitting the road, so to speak, which is a horrible expression to use in this case, since it was a car accident case. And before, just in setting the scene, before we leave the setting the scene, there is one state, Tennessee, that has done something a little different, right?
Is that the one they think they have a statutory amount
Yeah, they
for
have a
it? Like
statute. Yeah,
I think it's five or maybe $5,000 or
I
something
think it's
along those
a
lines.
$5,000 limit. Yeah, and it doesn't apply to veterinary malpractice, but it is it, since every court that considers this tends to say this is a matter for the legislature. It's worth noting that, well, one state did legislature did try to address it, though in every other state that has tried to address it, they haven't been able to get past the lobbies. But we'll get into the policy stuff a little bit more. But for the moment, let's talk about this case. And as usual, let's start with the facts. I think I mentioned that it was a car accident case, and I think these facts are pretty straightforward. So just tell us what happened, who these people were, that the incident that gave rise to this lawsuit.
Really, the immediate fact is walking a family dog through a crosswalk. So a driver just blew through the stop sign and almost hitting the woman who was walking the dog, who was on a leash, and but in fact hitting and then killing the dog, who died. There was a security camera across the street that caught the whole thing, like quite captured the whole incident quite clearly. This was in New York City as well. And one other fact that I think was pretty significant was that the dog had been the ring bearer for the couple's wedding
I didn't realize that.
previously.
Yeah, yeah.
Yeah, which to me I thought was really uh, I don't know that it's material because right your dog is still a member of the family even if they don't do it, but it really drove home that
Yeah, well, facts matter.
yeah. So there was no disputing that, and that this was a member of the family, according
Yeah.
um, in the eyes of this family, as it would be for almost anyone who has dogs or cats or other companion animals.
So, okay, since this is tort law, there are variations from state to state, but we're talking about New York law here, and it is dramatically different from other questions. And since liability, I mean, we won't talk about liability. It's not really an issue that's particularly at issue or of interest to us. But the primary issue here is damages, and that has to do with the cause of action that it brought, which of course is negligent infliction of emotional distress, which is a tough cause of action under any circumstances. And can you tell us what kind of harm this cause of action addresses? And specifically under New York law, what you need to show in order to recover for a negligent infliction case?
With a infliction of emotional distress, right? That means that you've suffered like a psychic injury that was, caused you to miss work or seek therapy or, other sorts of damage to your quality of life. And I think there's sort of an issue, like sort of a problem with that, which is that you could claim emotional distress for anything, right? Like, um, maybe I'm frustrated because there's traffic on the way somewhere. There's some car accident that's getting cleaned up to the side, and I'm, you could say, well, I was emotionally disturbed by that because I saw the wrecked car and it made me anxious to drive. So the way courts have, I think, the way we've dealt with it is putting limits on when you can claim emotional distress, and particularly in the case of negligence, when can you recover? So you have to be really, there's like two material requirements here, that someone has to be hurt, right? You have to witness someone being hurt. That person has to be a member of your immediate family, so that's the first requirement in New York. And the second requirement is you have to be within the zone of danger, right? So it's like you were right there, you almost got hurt yourself, and a member of your immediate family, in fact, instead of you, they got hurt, and you watched them suffer or perhaps die.
Right. So it's very limited. The circumstances under which this can apply are quite limited, and I think particularly so in New York. And as you say, it's not because other people aren't emotionally disturbed by what's happened. It's because too many of them are. Like, like if somebody is killed, like their cousins are upset, their aunts and uncles are upset, their friends are upset, people who knew them, like you at some point, the court said, okay, I mean, we just have to have some limits here. And they have to be pretty sharp because we're not talking about anybody who was injured. We're talking about, it's also a claim that could be fabricated. But even if it's not, I mean, a lot of people get upset when something terrible happens. What I think is so interesting here is that one of the reasons for that is to cut off liability. Tortfeasors can only be so liable. They're liable for the wrongful death, and they're liable for maybe loss of consortium or other causes of action. At some point, you have to say, well, enough is enough. They can't pay everybody who was harmed by this. In animal cases, they don't have to pay anything. No, there's no liability at all. Nobody has the right to recover because the animal can't recover. And so there's no enormous liability to cut off. So I really think these issues are very, very different, but I don't think the courts have recognized that. And that's why it's so important to have animal advocates in there explaining to the court exactly what the issues are. And as far as I know, the plaintiff here was not represented by a firm that specializes in animal issues. Not no shade. I mean, they might have been doing a great job, but how did you and other animal advocates get involved?
Before I answer that, I wanted to sort of amplify your point about how
Please,
with
please.
animals, there's not, the problem is there's too few liability. And I think that that's actually really problematic because if if you think about this through like a Chicago economic school of thought, like what are the incentives if you're a groomer, if you're boarding dogs as like a kennel, if you're making decisions like should we kind of negligently cram a bunch of dogs in a shed, or should we replace this like dryer that's been malfunctioning at the groomer? Um, if there's no liability, that's kind of a problem. Yeah, and even the fact that there's also some strange incentives as well, in negligence cases where you're better off killing the dog than you are leaving them like severely injured, but
Absolutely.
able to go to the
Absolutely. Yeah.
veterinary clinic and get treated. So it's just a very this kind of lack of liability, I think, creates like a really perverse incentive structure, and
Yeah.
given a lot of negligence at kennels, borders, dogs flying cargo and airlines. Like I could list off a bunch. Actually think maybe veterinarians, but I actually don't think that they're the worst of it because they're trying their best. That Yeah, very perverse incentive structure. So, anyways, that's an aside. You had asked about how we heard about this.
Yeah. And it wasn't just you. There were other animal advocates who filed briefs as well, weren't there?
Yes, yeah, there were.
The court
So
obviously uh, was and took them all very seriously as well. So it was obviously looking for information on the broader implications of this issue.
well, in July of 2024, so last summer, the trial court, who was figuring out what to do with this negligent infliction of emotional distress claim, and had it already briefed, I think, for summary judgment, sent out sort of an SOS, like an order listing off several animal groups, just kind of on all sides of kind of all ends of the spectrum, and saying like, please weigh in on this because I'm struggling with whether there should be a negligent infliction of emotional distress claim here. And so what that signaled to me is that the judge, I think, was picking up on the very inequity that we've been talking about in this conversation, right? How can like this? There's a sort of an absurd inequity with how these rules are working, and I believe even said at some point had watched the video footage as well of this happening. Maybe I don't know. Maybe the judge has dogs himself, maybe not, but seemed to be struggling with it. So just sent out an SOS, put out an order like if any of these groups want to weigh in as amicus at the trial court like summary judgment stage, like please do so. Like I'd love to hear from you, and here's like an amicus briefing schedule.
Does that
And
happen? I have to say I've never heard of that happening before. Like,
no, I have never seen that happen because the two really weird things about it were one, soliciting amicus briefs. I I don't think I've ever seen a court do that. Maybe it's happened once or twice that I've caught wind
yeah.
of, but in any context, I've never heard of a court doing that. In fact, a lot of times you'll hear appellate judges saying that, like a lot of amicus briefs aren't that helpful because they're just sort of,
Yeah. No, I spent most of my career working at an appellate court, and amicus briefs were mostly a pain in the ass, to be honest. Just
yeah.
like
So
people spouting their, who aren't that familiar with the case, spouting their own like opinion. But this is a very different issue because probably he was not the judge here. Was it a he? Yeah, Aaron, yeah.
yeah, yeah, it was.
Was not getting the kind of briefing that he needed.
Yeah, or feeling like there was some like unresolved question, like because yes, and well, and the other unusual thing too, this is a trial court, so trial courts usually don't even have rules to accept amicus briefs, and
Right.
they can. I've looked into this in the past in other contexts, like um, through like inherent authority of the court, like they can kind of do anything that's like reasonable, that's not going to get overturned as an abuse of discretion. So they can kind of make up any procedure as long as it's not abusive. Um, but that was also unusual. And there's a dynamic to this, and I think it really underlies a lot of animal law where you have to dig quite far below the surface to really understand the inequity that's going on, or to understand like kind of the flaw in the logic, that it's not as simple as going back to the last case in the 1980s or 90s that said um, there's no negligent infliction of emotional distress claim under these circumstances, right? Like that's sort of I don't know, the cookie cutter way of doing law, and it works most of the time. But animal law, I think, is different because of the like really like entrenched like historic like inequities that have been kind of like that are presumed and kind of baked into the way the law is functioning right now, and because of the fact that that animal law is going through like a growth spurt, and we're not. I don't think it's anywhere near finishing that growth spurt.
Yeah.
So there's a sort of a level of like research and digging deeper and like sort of exposing like unburying like really problematic flaws, and saying like that's wrong and you should do something about that, Your Honor.
Yeah, which brings up what I don't know whether you were on the list that the court solicited, but I would actually be surprised if you were, because I'm not sure this is an issue that you were particularly identified with. I mean, Non-Human Rights Project has, pursued impact litigation, and certainly in New York, so you're probably better known in New York courts than some other organizations. But, frequently the cases have involved elephants, other what they call charismatic megafauna, these big animals against institutional owners. And I don't recall Non-Human Rights Project being involved in this issue previously. Am I right? And why, if so, why did you decide to get involved this time?
Yeah, you're right. And the judge didn't include us on the list of organizations that he wanted to hear from. But he did acknowledge that the legal status of animals was being questioned, and cited the Happy case. So one of our very astute senior attorneys here at the Non-Human Rights Project, Spencer Lowe, has all these alerts set up, and anytime anyone sneezes and it sounds like Non-Human Rights Projects. So had to yeah. So he caught wind of this, and because of the Happy reference, and then so that begs the question: why does a group that's spent so much time on habeas corpus right to liberty for chimpanzees and elephants, what does this companion animal valuation have to do with our work? And the short answer to that is that um, we're common law nerds. That's really what the basis of our habeas
Yeah.
corpus argument is. And the negligent infliction of emotional distress is it's a common law claim. And I could there's reasons why that's like important and germane, but it actually it links up really strongly with our work, if you look past the surface level.
Yeah, it actually brings up, I had pulled out this quote. I don't know from where, but I think you said it. And it just really struck me that courts have a responsibility, not just the authority, to advance animal legal status through the common law. I think that's just so important to remember. This isn't optional on the part of the courts, whether they struggle with these issues. It's their responsibility to do that. And also, I just thought, uh, something that you're obviously aware of, but that Steve Wise, who of course was the founder of the Non-Human Rights Project, a lot of the work he did, to keep himself alive, and his actual practice had to do with this issue, interestingly enough, though I'm not sure whether he considered it part of the Non-Human Rights Project work. But, there obviously are connections, because he was also the original common law nerd. Um, so you're in Brooklyn, I understand, in what we call in New York Supreme Court, which confuses everybody else in the country, because that's our trial court, is our Supreme Court. And so were there causes of action that were brought other than negligent infliction? There was a property damage uh, cause of action brought as well, right? Loss of property.
Yeah, I think so. That those are a little fuzzier to me, just simply because it's
All right.
and probably to the I would say even to the litigants themselves, because that's easy to resolve. Here's a $500 check. Go buy a new dog.
Well,
So
but I would like to talk about that a bit if we have time, but I'll save that to the end, because that's just one of my hobby horses. I think the main argument here, as you already laid out, was this definition of family member. In the cases that have laid out this cause of action, they talk about how it involves specific family members who have been injured in these particular circumstances that can give rise to this kind of liability. So you want to expand that definition. Can you just kind of summarize what your argument is for why that does apply to a beloved dog?
yeah, and there's maybe sort of two aspects to that I really want to key in on. So one is that, well, in New York, the definition of family member had recently been expanded by the New York Court of Appeal to include grandparents, right? And the idea, this is sort of in line with modern family law trends, which is more about like a sort of a chosen family and not necessarily like a nuclear like one generation removed, parent child sibling sort of definition of immediate family. So had been a decision a few years ago, it was called the Green decision, that extended that to beyond that sort of nuclear family. So the question then, of course, is like, well, can this extension include a non-human family member as well? And the answer to that is really going back to like basic principles of common law interpretation and evolution, which is like that courts are supposed to consider, societal norms, like interests of like justice and equity and fairness in deciding whether to, extend or evolve or modify or kind of reinterpret, I suppose, a common law doctrine. And so our argument was really like, look, this is really out of line with how people feel about their animals, and in a way that's like just profoundly unfair, and therefore in violation of your common law power. We cited public opinion surveys, like people are asked, are your dogs or companion animals a member of your family, or are they like property, or what are they? And the overwhelming majority of people like refer to them as family, and barely anyone refers to their companion animals as property. So that's clearly out of step with societal norms, right? And that's super important, right? Like who's a judge to say that like they're not a member of your family when like 90% of Americans would say that they're part of your family? Like it's sort of like, why the obstinance, right? And of course it's unfair, right? It's inequitable.
It's
So
crazy.
yeah.
It really is crazy.
Yeah, and if I could sort of accent one point too, which is you'd mentioned earlier the idea of that common law, that courts, when they're exercising their common law powers, they don't just have the authority, but they actually have a responsibility to do something. I think that was really an emphasis that we had that was really important and strategically designed, because there's this, I think I think part of the thing that's holding judges back is a sort of like an amount of shyness about using their power, right? Like I think there's this like stigma about being an activist judge, but when your own high court precedent says you have a responsibility, like they literally, obligation, responsibility, like this, it's very, very, very strong, unambiguous language from high court in New York and other states as well, that you're supposed to evolve the common law. Like you're not supposed to say crazy things like, dogs aren't members of the family ever. You're not supposed to say that. You're supposed to like do justice. That's what you're supposed to do. And if doing justice, is a problem, like it's not the legislature's job to like solve every injustice, right? It's the court's job it's the job of the justice system to do justice. And
Yeah, especially when it's a common law issue, which means that the courts have the power to do that.
right, and a responsibility. And it's
Yeah.
actually the proper balance of power there is for the court to act justly, and then there is a political process where uh, you could do legislation, or if need be constitutional amendments, if the people want to kind of redefine justice, but in some way, like that's a safety valve as well, but that doesn't but I think there's this like inertia, this like fear of doing justice. And so a big strategic goal of ours in filing this amicus brief was to try to embolden courts to do justice.
I had asked about the amicus briefs, but I forgot to ask about the fact that there were also a great deal of amicus briefs on the other side. And I think in this context of the question of, do we expand the definition of family member, it's really important to consider the very odd position that so many of the opposition groups are in. who really rely, they're all business interests that completely rely on animals being considered family members. And can you talk about a little bit about who was on the other side, who filed some of the amicus briefs? There were a lot of them. Obviously, this really caught the attention of the industry.
Yeah, the key ones is this is sort of like I'm trying to think of the right. I don't want to call them evil because I don't. I like to try to see the best in people, but this I guess economically motivated trade group coalition that weighs in on these issues whenever they really wherever they appear. So, and really the main ones are like the American Veterinary Medical Association, American Kennel
I'd be
Club.
happy to use the word evil. I'll do it for you.
I really
I
try to
don't have
see
to
the best.
litigate.
You know, humans are animals too, so I try to I try to have a try to keep that in mind. But it is it's greed. It's economic. It's purely economically motivated. So yeah, um, the Cat Fancier Association. So it's really these are some of the main ones that come to mind. But it's the trade groups like veterinarians and breeders essentially.
Even though obviously their interests were not involved in this particular case, which was about a car accident, they still don't hesitate to jump in. I just like to bring up a couple of issues that have come up in other cases. One thing I've always thought of as interesting in Wisconsin, when this case reached the um the top court, the court felt that there were too many possible species that could be included. What's your response? Like people can have relationships with all sorts of different animals. Does that really matter?
Earlier, I was talking about trying to like unbury like sort of deep injustices.
Yeah.
So on the surface level, maybe there's these, well, oh, what if you were really bonded to your pet iguana or something? Well, okay, if you dig deep enough, you go back to the like Middle Ages and the where like that purpose of tort law that's really like been the foundation of American tort law was established, and it was to fairly compensate victims of wrongdoing. That's the purpose of tort law. And I don't. There's nothing in there about policing, non-human species lines. There's nothing in there about that. Really the question is like, what's fair and reasonable compensation? Like that's the starting point. And it's yeah. So these sorts of concerns about it's not reasonable to like love some species who are companions, or concerns about some marginal effect on insurance rates for veterinary professions or so forth. Those are, in my view, those are policy concerns, and it's activist for judges to worry about those instead of the fundamental equities and fundamental principles of the case. So it's this like again this like strange world where everything's kind of upside down, and the activist judges are actually the ones that are policing this boundary based on policy considerations that belong to the legislature.
That is an excellent point. It's the judge's role to apply the law. If the law needs to be changed, it's the legislature's role. And yet they're really changing the law in this particular area in some ways. I mean, you could look at it that way anyway. I think we should get to the decision because I've been doodling around asking you about positions, but I really want to get to the decision because this was a very serious, well thought out, complex decision. I mean that the kind you don't see in animal law cases a whole lot. So that in and of itself is reassuring. And the court definitely recognized and acknowledged that it was treading new ground. I think that it was bound by precedent, and its decision was really rather narrow, um, and that may have been both because the court wanted to limit how far the decision went, but also because the court is a trial court. I mean, they can't, if the appellate courts have already decided something, they have to find their way through that, and I think the court did that very admirably. And didn't change the immediate family requirement, found that at least certain companion animals should be included in the definition. I don't know whether the court actually wanted its decision to be so limited to this very particular factual situation, or whether the court just had to make sure it was very limited in order to fit through precedent. But it really did end up being a very narrow decision, groundbreaking, but at the same time narrow, just applying to this very particular factual situation. So what were some of the limitations on, I mean, we're not talking about vet malpractice here, that's for sure. It's very limited to this particular situation, right?
Yeah, the court navigated the issue that there was already negative appellate precedent on the question of negligent infliction of emotional distress by distinguishing this case from other cases from that previous precedent. And so the fact emphasizing that where the companion animal is a dog, where the family member is in the zone of danger, and even attached significance to the fact that the dog was on a leash, which that was a detail that wasn't included in prior precedent, but it does add to the zone of danger, because if you're tethered to the animal when they're hit, that increases the magnitude of danger to you as well. And I think that the trial court was technically right to do this, to distinguish it in this way, say uh, under these sort of enhanced circumstances, it is in fact, um, there is no precedent with that level of circumstance to it. And so, yeah. Now, did they want it to be? Would they maybe hope for something that's like more expansive? All we know is what they wrote, so who knows? But I mean, but certainly the fact that this rule is like so inequitable in the first place, the limitation on tort damages for companion animals is so unfair, and it goes so harshly against like sort of common sense, and the fact that the judge wrote such a detailed analysis, and went to the lengths to be so technically correct that he could sidestep the prior precedent. I think is quite telling. Yeah.
Yeah, and it's the common law. The court just has to decide the case that is before it, and different changes can wait for different moments when there's a different case. And though, of course, those in opposition still lost their minds as if the floodgates were opening. And floodgates are certainly a word that they love to use. They definitely love to use it. And I think there are actually two aspects to their floodgates arguments. First, if we're counting companion animals as family members, wouldn't we include like best friend? Like, wouldn't we have to include all sorts of humans? Like, what is like your best friend? Does it, if your best friend is killed, obviously you're going to be upset too. And I think that harkens back to what we were saying before about, well, if your best human friend is killed, there's other forms of compensation that will be had, many. Whereas with animals, there will be nothing. Are there any other reasons that we would extend it to your dog and not your best friend that you put in your argument?
Well, they are members of the household.
True.
So yeah, I think that's important. And if the going back to like surveys as well, like people use the language of family to describe their companion animals. So
Yeah.
that's something that doesn't apply to like a best friend, or um, I mean even to a roommate. So uh, yes, so there are, I think, just quite a few distinguishing characteristics, and it's a strong argument.
But the other floodgates argument, which I think is really their big argument, seems to be based on this idea that there are all these animals out there, and apparently they're being negligently harmed all the time, and there are all these potential lawsuits. So there would be so much litigation. But isn't that what the courts are for? And isn't it a problem if all of these animals are being negligently harmed or killed? I mean, it's such a weird position that they are in making this argument, I think. But that is, I think, pretty much the argument that this would just, and of course, they like to act as if all of the litigation would be pretextual, and it would just, harass the courts with frivolous litigation, which of course courts have ways of addressing frivolous litigation. It's not like this would be the only area in which there would be frivolous litigation. How did the court address this floodgate concern?
Well, first of all, by going back to the narrowness of the
Yeah,
holding, right, which I think
yeah,
was appropriate at this trial court stage,
yeah,
and
absolutely.
the issue, if it gets addressed on appeal, might be more holistic than that. But yeah, so I certainly think that's one way of it. And you're right. There's this tension in this argument where it's like either there's this like a lot of injustice that's going uncorrected, um, right? Like, well, so the problem is too much justice. Like I mean, that's kind of an
Right,
insane thing to say,
right,
and that's not
right.
just for torts, but it's also for I see this with like cases against like factory farms, for example. Like we see it in we get dogged with this, for lack of a better word, all the time in our habeas corpus cases that it's gonna, what's the limit? Like if, but if it's just, then you're the justice system. Do it. Like you
Yeah,
do it. Or their other claim is that this would be frivolous, right? Like that they would just get harassed with frivolous claims. And you're right, there are ways of dealing with that as well, right? You can do sanctions. There's motions to dismiss. I think they're quite wrong. Like just it, people are motivated to bring frivolous lawsuits for harassment purposes. Like lawyers like winning cases. we don't like losing them, and there has to be some motivation to take the case, and that's either going to be money if it's a damages case and it's a private lawyer, or it's going to be that you're going to win and have a good impact if it's like being done pro bono by like a nonprofit or you know or someone who's not getting paid at all. So there's all in my view actually the problem's the opposite. I'm worried that if we open the gates, that there's still just going to be a trickle going through potentially in a lot of sort of areas of animal law. So I think it is the wrong concern, and again that feels like a policy concern, right? Like court administrative burden is not like one of the like factors of common law evolution analysis, right? It's like liberty, justice, equality,
yeah.
fairness. Those are the important considerations.
It almost is as if there's an underlying sense, which I think there's some truth in, that our treatment of animals is in so many instances so bad that if we start addressing it, we don't know what we're going to have to do. And, there's actually some truth in that, but that's not a reason to ignore it.
Well, I think that gets to questions about like cognitive dissonance and moral schizophrenia, which is like
Yeah,
pretty well
yeah,
discussed in terms of like consumer choices, like whether you go to the
yeah.
zoo, whether you eat bacon and eggs. Um, that there's this kind of yeah, this is like a psychological dissonance, and I actually strong. I don't know if I believe it because I just have sort of anecdotal experiential evidence for it, but to me it really seems like that's what's going on even at the legal system, because of course judges are human too, right? And I'll plug an interesting essay on this too by Matthew Liebman, who I worked with at the Animal Legal Defense Fund. It's a spin on the legal realism, like what the judge ate for breakfast, like might determine like
Yeah,
how they rule that day. But and Matthew's spin on it was just like who the judge ate for breakfast.
yeah, exactly. Yeah, no, the underlying issues like pop up everywhere in everything we have to do with animals. But getting back to the case itself, I don't want to stop talking about the decision without mentioning, um, the court noted that there have been a lot of changes in New York law, and that I think gave the court some basis to go a little further, which just shows you that all of the work that animal advocates have done, like to get these little changes, can lead to better changes. Particularly, I think the best interest standard in divorce cases, and I think the trust issue, which happened a long time ago, that you could have a pet trust, and all of these things give courts a little boost to allow them kind of to do, even though it's a different issue, to allow them to do the right thing. Do you agree?
Yeah, yeah, and that kind of goes back to the reason why the Non-Human Rights Project, even though we're focused on fundamental rights for animals, and there's you know companion animal economic valuation under tort law doesn't quite it doesn't exactly gel with like our historic work, but there's kind of like a congruency, right, of all these things working together and sort
Yeah.
of painting a picture. And I think it'd be incongruent to say, for example, that like we're not going to uh, exercise our common law obligation and authority to recognize that companion animals are members of the family, which like 90% of people that you would poll in New York would agree with, right? To say that, but then to deny that kind of common law evolution, but then to evolve the common law with regards to bodily liberty for an elephant. I think a lot of this kind of works in tandem. They don't. It does. It's not like A necessarily implies B, but when you have these factors kind of working together, it starts to paint
Yeah.
a picture, and when you connect the dots, yeah, it all kind of rises and falls
Yeah.
together.
And gives the court less feeling that they are at risk in holding something new and animal supportive. They won't be made fun of or considered ridiculous because there's all this other stuff going on. It's all extremely important. Now, if there's nothing else you want to talk about with the decision, there was something I promised I wanted to address. It's the property value. I think the actual owner of the dog was the son, and his negligent infliction claim was dismissed because he wasn't there. He wasn't in the zone of danger. But they did award him the dog's inherent value, not market value, inherent value. Which I thought was really interesting because I'm not exactly sure how that's defined in New York law. I'm not sure anybody is. As far as I can figure, they're only seeking $1,500. But can you just discuss a bit about how dogs and other companion animals have traditionally been valued as property? And and I've always wondered whether the value of companionship, which is an enormous value, similar to loss of consortium, could be thrown into that value, which would take it, I think, way over $1,500, in my opinion. Like if you're sticking to a property analysis, whole different analysis of this exact same facts, but a different theory of recovery. We're not recovering for what happened to the plaintiff, Nan DeBlaze, um, that she was emotionally traumatized, and measuring it by how much trauma she suffered. She lost property. How much was the property worth? How much is this dog worth? And I know that the Non-Human Rights Project is not really fond of arguments that value animals as property. But if you start valuing them a little higher as property, maybe there would be another way to litigate these cases. Different theories, same facts. All right. I don't know whether you want to offer anything on that or you just allowing me to expound my favorite theory.
Well, I think something that you're hitting on there is that the loss of the companion animal, the grief, the not being able to go on hikes with them, the traumatic memory that you're always going to hold on to for the rest of your life when you think about them. That there's actually like several ways to go about that. Like the tort system actually has several overlapping ways that you could provide
Yeah.
some sort of fair
Yeah.
compensation for that, right?
Exactly.
Through
Yeah.
through
Yeah.
like kind of a wrongful death or a loss of companionship, through emotional distress, or through yeah, this kind of like intrinsic valuation, which is for property that's not where there's not like a market, right, for that particular kind of property, and so I think that to me that really just adds to the inequity of not recognizing it for any of them, because it's actually sort of this like compounded inequity where you're saying, even though there's like multiple overlapping ways that we could provide some kind of like compensation for your experience, for this terrible experience, like we're just going to say no to all of it. And again, to me that starts to look more like that is more like judicial activism
Yeah.
than it would be to allow some of this through. So that's sort of my main reaction there, and I do think that the intrinsic value actually could be higher, like could be much higher, because like
I
what's
think
what's
it should be much higher.
what's yeah, I completely
How much is
agreed.
your dog worth to you? Like if you had to give up your dog or your car, which one is going? Like how much money do people spend on vet care for their animals. I mean, these values are very, very high. Um, and yet to value the animal. I mean, as I said, I think if I'm reading the decision correctly, is all they asked for $1,500. I do think there's New York appellate law on this issue at the mid level, which kind of forecloses it. But you know, this case is going up on appeal, right? So maybe that could be. I mean, this trial court may not have been comfortable going in that direction, but I can see including value of companionship or however you want to characterize it in the value of the animal. I think that's what we value in our animals. We don't value whether they can do tricks. Well, maybe a little bit.
Completely agree. In a way, it sort of depends, like, how do you, like, at what level of abstraction or generality do you define the, like, the property that you're trying to evaluate? Is it like a dog? How much does it cost to buy another dachshund from a breeder, or go to the shelter to get one? Or is it this particular dog, right? Um, and that's like actually like kind of that's like almost priceless. Really,
Yeah,
if
yeah.
it's they're going to respond to the name, they're going to evoke this like this feeling of love and bond and memories together when you go to your favorite park together. And if you just buy a replacement dog, you're not.
You
It's
don't
not.
get any of that. We
It's
all
not
know that. This is so
exactly.
obviously true. All right, so the New York's high, I mentioned there were a couple of appellate court decisions, but New York's highest court, which we eccentrically call the Court of Appeals, even though it is the highest court because we've already used up the term Supreme Court, has actually never reached this issue. Is that correct? And in other states, the highest court, as we mentioned before, has ultimately rejected it. Do you think this is the case? It's going to go up?
It's true that a lot of high courts haven't addressed the issue, although over the last like 10 years or so there have been a handful. So it is really a hot issue. Unfortunately, most of them, or perhaps all of them, really not going in the right direction that they should be on this. So I do hope that this one goes to the New York Court of Appeal, and there has been a notice of appeal filed, so it is going to go through an appellate process. I think there's some reasons to be optimistic here, right? Two of the judges that are on the New York Court of Appeal right now ruled in favor of bodily liberty for an elephant under a common
Yeah.
law expansion. So I would think that there's going to be at least a few members of the court who are open to this and really take a hard, fair look at it. So I have some optimism that this case or another one in New York could be the one to finally really break through this historic inequity.
Yeah, and it might help that this is a very narrow holding, and that's how the common law works. It can be broadened in the next case. It doesn't have to, you don't have to decide the whole thing all at once. So since last we spoke, you have left ALDF. I think the last time I interviewed you, you were still with ALDF to head up the Non-Human Rights Project. I mean, I want to hear what's happening there aside from this case, but I also want to hear your perspective on, given what's happening to animals and the world and democracy and the whole big picture and the crisis of factory farming, why does this issue matter?
I think it's really symbolic of the entire sort of injustice with animals because what you have here in the non-human rights project cases, which for people who aren't familiar, it's these are state common law habeas corpus cases, and we're bringing them on behalf of like animals with a scientifically like indisputable uh, degree of like cognitive autonomy. No matter how narrowly you define it, right? They like elephants and great apes that have language, like chosen families, preferences about like what to do, personalities, like self-awareness, yes, the ability to recognize themselves in a mirror, like memory, planning for the future, like by really any sort of measure or standard of autonomy, they're autonomous. And so we're asking courts to recognize that they have precisely the kind of liberty interests that are supposed to be protected by habeas corpus. And habeas corpus, really the sort of simple way of explaining it is it provides individuals with a like a procedure to free themselves or to become free from an unlawful or a wrongful confinement. Essentially, we're trying to protect their liberty interest. Like the law cares about liberty, they care about liberty, so courts should care about their liberty. The key part there is whether they're non-human or human. It shouldn't matter if you're non-human if you have a strong liberty interest. And so that's why our work is important beyond the suffering of the individuals who we're bringing these cases on behalf of. Right, there's evidence, for example, elephants in zoos, they lack so much enrichment in space that they actually suffer brain damage. They are commonly engaging in like stereotypic behavior. Uh, in colder climates, they're like left in barns for several months over the course of the winter, taken from their family, um, you know, forcibly bred, and then their offspring are taken from them to go to other zoos. So it's really a horrible system. It's a horrible injustice for them, but it's really, at its core, confronting the justice system with like this idea that you can matter even if you're not human. And so that's why this is so important.
Yeah, I think I mean, this is an incredibly important moment of change, and this is one of the things that we definitely have to change. I am very grateful for the work that you're doing, the big picture kind of work. Because with animals, there's so much suffering, it is easy to get drawn into like addressing the individual issues of suffering, and it's very important for somebody to be doing that big picture. Um, so, can you go into a little bit more specifics about what's going on at NHRP?
Yeah, I wanted to sort of like add to the stakes or sort of explain my own like personal like why I
Please,
gravitate towards this area as well.
please go ahead.
Which is really just my frustration with the status quo at ALDF, right? Like one of the things that I did a lot there were like bringing animal cruelty sort of cases, but through like a private right of action, trying to, you have a prosecutor who's a government who's not doing anything for an animal cruelty or an animal welfare act case even. So how can private advocates sort of get that restraining order or injunction the way that we easily would be able to if they were human victims of some sort of violence or neglect. And it was just so frustrating. Um, right, there's this theory of standing called like a haven standing, where an organization that like diverts resources to counteract some or in response to some illegal activity towards animals, like they can sort of claim that diversion of resources, right, like sending a letter to the prosecutor, like politely asking them to enforce the law, that those sorts of activities were the basis for standing. And sometimes we would win those, and sometimes the courts would say we don't, that it was a self-inflicted injury or something like that. And like there was this sort of like nibbling around the edge quality to like the standard playbook, the one that's like successful most of the time, in over 50% of cases. Like ALDF has a great track record, but it was really like gnawing at me that there were so many like filters and limitations, and that the solution is like that the animals matter, like that they should matter in the eyes of the legal system, and that the problem with like in a cruelty case isn't that the animal, that some human went to the zoo and like saw an animal in a bad condition. Like that's not the core problem. And so while this isn't, um, the Non-Human Rights Project hasn't brought like anti-cruelty cases or anything like that. What the Non-Human Rights Project has done like really successfully is like just saying like we're bringing this case on behalf of the animal. It's the injury to the animal that matters. Like Non-Human Rights Project on behalf of Happy, and have generated like a worldwide conversation about that, and had several judges, including three on the New York Court of Appeal, like writing sympathetically about us. So there's something that I think that's really resonant about this, the honesty and directness of calling a spade, right? So I think it's a really like inspirational organization. And this like sort of animal-centered approach to animal law is, I think, exactly what's needed. So, excited to to be a part of that and to work with all the brilliant minds at the Non-Human Rights Project to make the world a better place in this regard.
Yeah, it's incredibly valuable work. Can you just tell us a few specific things that you're working on?
Yeah, so I think this amicus strategy is something that we're experimenting with, and it kind of goes to that same core issue that I was talking about. Like the reason that the Non-Human Rights Project is so valuable is because we're trying to say that non-human individuals can matter, and that there's something that's almost kind of activist about denying that, about sort of you know saying that a dog's not a member of the family, or to say that Happy doesn't care about her liberty. And so dismantling that really the bias against non-human individuals and the denial of their legal status is something that's common amongst both our liberty cases and the Blas case. We'd also filed an amicus brief in a right to rescue case in California, and that's a case where activists had walked onto a factory farm and taken like what they evidence appears to support, and what they say were animals who were being neglected and dying, and save them. And the particular issue that we weighed in on was purely whether as a common law defense, the right to necessity should recognize that cruelty to animals is a significant evil. Because that's at issue in that appeal, whether animal cruelty is a significant evil. And we kind of along the same basis that like non-human animals matter, that there's a sort of incongruity to having the common law like not advance in these important ways. We're wanting to help sort of foster these like sort of other like tangential issues to our main work in order to inspire judges to use their common law power. That's kind of like one bucket that we're doing. And then another thing that I'm really excited about too is we're really doing a deep dive into research. Thanks to Rebecca Garverman, who was on your podcast a few months ago when she was joining us to do a deep dive into what we're calling like procedural rights for animals. And that's some of these maybe not as headline grabbing as like bodily liberty, but I think still really important, which is like the ability to like file the thing and to get the hearing, to get the remedy, to actually support your case. These sorts of procedural rights are actually extremely important because in order to have really like any right at all, you have to be able to get to the end of
Yeah.
the finish line. You have to be able to get through your entire process. You need to be able to get to have your day in court where you try to prove your claim, and you need to be able to get an enforceable remedy as well. And I think that that's something that gets overlooked a lot, not just in like the animal rights discussion, like they're just their right to have like a legal process, but also in the animal movement kind of at large is this like bottleneck that it's like so hard to even just get into court, to have
Yeah.
standing, to have a right of action, to enforce laws, whether it's a common law right to bodily liberty or whether it's like kind of like a statutory right not to be abused or neglected, that animals should be recognized and have the ability to do that. So we're sort of exploring that space and see if there have been any overlooked opportunities there that we should be investing more of our
That
bandwidth into.
sounds very exciting. I'm looking forward to hearing more about that because I think there are many hidden opportunities, especially in like, well, not especially, but to some extent, just in the statutes, like the 50 different sets of very complicated, sometimes archaic statutes. Actually, there could be some opportunities there. So I'm very, very happy to hear that you're looking into all of those topics, and we'll be looking forward to hearing more from you. And unless there's anything that I didn't ask you that you wish I had asked you, I guess it's time to tie this up. And I'm so grateful to you for joining us today.
Yeah, well, thanks for having me, and I was super happy to talk. Maybe I'll end with what an illustration on that last point about there being opportunities in the statutes. I actually
Please.
think that like one illustration that really drove this problem home for me was in California. Like we celebrate Prop 2, which was a proposition that cost millions of dollars. It was like national story in 2008 that said, hens in battery cages, calves raised for veal in crates, and gestating pigs, like had to have enough room to like stand up and turn around, trying to abolish like the extreme confinement of those three types of farming. That was in 2008, but in 1970, or it was maybe 71, the state of California enacted like actually what appears to be a much broader version of that, which simply said anyone who confines an animal shall provide it with an adequate exercise area. So
It's so crazy that that law exists. It's so crazy.
Penal Code 597T, if anyone wants to look it up. And to me, it should have applied to like extreme confinement, and yet there was no example of a prosecutor ever enforcing this against like intensive confinement on a factory farm. Clearly, the factory farms themselves either didn't know about it or they knew about it and they just thought they could get away with it, which they did. And then there were a series of cases by animal groups. There were like four cases brought by like Humane Society of the United States, Humane World now, ALDF, I think Farm Sanctuary had one as well, trying to do this through like civil means, saying like, oh, this is like a violation of consumer protection laws because like this
Right.
cruelly produced milk was sold to people.
Right.
And all of those cases failed on standing grounds or like right of action grounds. Like there was no procedure by which so the court never ruled on the merits of those claims, even when advocates were pushing the issue. Instead, they were just like flushed down the drain on these procedural questions. And that's just like one example, right? One state, one case study. So just imagine a world where our rights, our right to vote, our right to free speech, where our right not to be like stalked or harassed or assaulted, our right not to be discriminated against, right? Like imagine if all of these legal rights, like we still kind of kept them on paper, but the only way to enforce it would be to write a letter to the government and hope that somebody at the government would bring the claim for you. Like, would anyone consider that acceptable? I think the answer would clearly be no. So this is to me, just like a huge, huge bottleneck. And legal rights for animals is I think the best solution to that.
Yeah, absolutely. Very exciting work and really ties into these dire times we're living in. They are dire, but changing times present opportunities, and let's hope that they do for animals. So, thanks for joining us today, Christopher.
Thanks for having me.
And thanks to all of you for tuning into the Animal Law Podcast. Please remember to subscribe on your favorite podcatcher and/or on YouTube. Thank you so much to Vicki Beechler, Jen Riley, and Akbar Khan for their assistance in producing this episode. And I'll see you next week on the Our Hen House podcast, which will start with rising anxieties on Tuesday.